Hello, dear students. I am Ömer Ali Girgin, and I am a research assistant in Anadolu University, Faculty of Law, in Civil Law Department. And I am here to introduce you the Introduction to Law book and Chapter 5. Today's topic is Chapter 5 is Criminal Law, and we hope that you will understand the following subjects after this chapter: definition of crime and criminal law, what constitutes a crime, elements of crime, basic knowledge with regard to criminalization theories, purposes of punishment, reasons which would justify or excuse a criminal act. These topics that I hope that you will understand and you can explain after this chapter. So as you see, our topic is criminal law. I will try to explain you in many different aspects of criminal law. So as always, we will begin with the definition of crime and criminal law terms. So here is a textbook definition of crime, which is: a crime is an act committed or omitted in violation of public law, either forbidding or commanding it. So what is criminal law? Let's see. Criminal law is a branch of law which analyzes the reasons of crime, definition of crime, and punishment. Purpose of criminal law is to protect society and to provide public security. We have three kinds of theories of punishment. Let's see them. Let's have a look at them. Absolute theories of punishment is about looking at the past. It's about revenge. And relative theories of punishment looks into the future, and it's about public's fear of being punished. I will explain this later. And unified theories of punishment looks both past and to the future. Absolute theories of punishment looks into the past. We just said, and by saying this, we mean that people hope the punishment will give a relief to them. They take revenge and they feel better. And relative theories of punishment looks into the future. We just said a criminal gets punished, so the public think that if I do this act, if I commit a crime, so I can be also get punished, so I mustn't do this act. I mustn't commit a crime. So unified theories of punishment just unifies the both absolute and relative theories. Okay, let's continue with criminal law consists of two sections: a general and a special part. In general, principles that are applied to every kind of crime regulated in the special part are located in the general part, defining the specific crimes and arranging them into the groups by subject matter pertain to the special part of criminal law. The general principles are the fundamental regulations and apply without exception to defined crimes in special part. Pursuant of the TPC, which is Turkish Penal Code, Article 1 to 76 contains general regulations that are applicable to every kind of specific crime. This special part of criminal law defines specific crimes according to the principles set out in the general part. So we can say Turkish Penal Code consists of two sections, which is general part and a special part. What are the sources of criminal law? Legislature, as always, criminal prohibitions and sanctions should be based on written law. Judiciary, the role of the jurisdiction is to interpret the criminal law. Here is very important. This sentence is very important because the role of the jurisdiction is to interpret the criminal law, not to create them. This is very important. Executives, steps in especially in solving specific technical issues. So there are some principles in criminal law, which are the principle of personal responsibility. Only the perpetrator gets punished, not anyone else. The principle of legality. An act can only be punished if the law regulated it before. The presumption of innocence, no one is accused until proven guilty. These are very, very important principles to follow in criminal law. So, liability requirements. This topic examines a person who is punishable. So let's say it again. In other words, who can be punished? If a person does an act which is defined as a crime in Turkish Penal Code, and can he be punished? Does he have a capacity to commit a crime or capacity to get punished? The two main elements required for a crime to have been committed are guilty act and guilty mind. Liability requirements, there are two of them: objective element and subjective element. Objective element, either a voluntary act or omissions. Subjective element is either intention or negligence. So these two requirements, these two elements, if they don't exist in an act of a person, we cannot punish that person. We can summarize like this. So excuses, what are excuses? Excuses are the third step in determining the person's individual accountability for the wrongdoing. There are several ways in which accused persons may try to reduce the level of liability for the alleged offense or lower the level of punishment if convicted. Even though excuses do not abolish the existence of the offense, they reduce the level of or remove the liability of the perpetrator. Excuses are, we can count like this: necessity, mistake, insanity and diminished responsibility, infancy, intoxication, coercion, provocation. So today's chapter is done with the excuses part. Thank you for listening.